Welcome to Mayor Brown's Tech Talks podcast. Each podcast is designed to provide insights on legal issues relating to technology and IP transactions and keep you up to date on the latest trends in growth and innovation, digital transformation, IP and data monetization, and operational improvement by drawing on the perspectives of practitioners who have executed technology and IP transactions around the world. You can subscribe to the show on all major podcasting platforms. We hope you enjoy the program.
Hello and welcome to Tech Talks. Our topic today is IP integration in M&A deals, global tax and IP risks. When a company acquires new technology through a merger or acquisition, the next challenge is figuring out how to integrate that IP across the organization. And that's often where the real risk begins. I'm your host, Julian DeBell, partner in Mayor Brown's Technology and IP Transactions practice. I'm joined by two of my Mayor Brown colleagues, James Ferguson and Jason Osborne. James, or Jim as we know him, is a partner in our Chicago office whose practice focuses on intellectual property litigation, complex commercial litigation, and both U.S. and international arbitration. Jason is also a partner based in Washington, D.C. He works with multinational clients to solve complex international tax and transfer pricing challenges, helping them optimize cross-border structures and navigate disputes with tax authorities around the world. Jim, Jason, welcome to Tech Talks.
Thanks, Julian. Great to be here.
Always a pleasure. Thanks for having us.
Okay, great. Well, let's start with the basics. When companies buy a business and acquire technology in that way, why does IP integration matter?
That's a great question, Julian. Most people assume that once the company acquires the IP, it just automatically becomes part of the company's portfolio. But in practice, the acquiring company has to make sure that the right affiliates within its global organization actually have the rights to use that IP. Getting the IP right will generally depend on two things. The first is the nature of the IP. Are we talking about patents, trade secrets, trademarks, copyrights? Second question is how the IP will be used. Will it be used, for example, to make and market existing products? Will it be used to conduct new lines of research? Or will it be used to sell or license the technology to third parties and so on? This usually means that setting up a well thought out intercompany licensing structure, a licensing structure that identifies first, which affiliates will be the legal owner of the IP, second, which affiliates will be the licensees of the IP, and third, what kinds of licenses the affiliates will have. This is a very important step in the process of IP integration.
All right, and to be clear, in all these cases, you're talking about internal licenses between related companies under the same corporate umbrella. Is that right?
Exactly. These are intragroup licenses, but they're just as critical as external licenses with third parties. Without them, the company might find that its affiliates don't have the rights they need to operate, or that the company can't enforce those rights in court if a third party were to infringe the IP.
And I'll add that from a tax side, these intergroup licenses can really have huge implications. So, like whenever you transfer or license IP rights between different affiliates around the world, it can trigger significant and sometimes adverse tax consequences. Like, so for instance, if you're a parent company that licenses IP to an affiliate in another country, I should always consider the risk that a tax authority could claim that there's been an effective transfer of the IP and then try to impose an exit tax. Or alternatively, the tax authority might try to challenge a valuation of the IP transferred or the rate of the royalty charged.
Okay. So a structure that's meant to simplify internal operations can actually make things riskier, both for IP enforcement and tax compliance.
That's exactly right, Julian. The challenge is to design a structure that works for both purposes, IP enforcement and tax compliance, without creating unintended liabilities.
Okay, well, let's dig into the tax side a little more. Jason, you mentioned exit taxes. What are those and how do they arise in this context?
Sure, Julian. So, like whenever you license IP rights between affiliates in different countries, you need to consider the risk that a tax authority may treat the license as if you effectively transferred ownership of the IP. Deemed sale is sometimes called, even though you have not transferred legal title. And that's because in many jurisdictions, the tax law says, unlike intellectual property law, there's a concept of economic ownership distinct from legal ownership. Economic ownership refers to the entity that the tax law views as the owner in substance. And to determine economic ownership, tax authorities they would historically look to the parties' contracts first, and then they would look to see like which entity is bearing the cost of development and assuming the risk. But increasingly, the tax authorities are looking further to see like which party performs and controls the development, enhancement, maintenance, protection, and exploitation functions for the IP, the so-called DEMPE functions. So, for example, if you're a U.S. parent that acquires a foreign subsidiary, and post-acquisition, the new subsidiary licenses its IP to the U.S. parent, and the U.S. parent takes over responsibility for development and enhancement of the acquired IP. The local tax authority might then say, well, you've effectively transferred the IP to the US parent. And then they'll impose an exit tax on the value of the IP that's deemed to have been transferred out of the subsidiary's jurisdiction.
And that's even though the parent technically still owns the IP.
Exactly. On one case, illustrated just that. In this case, a U.S. company had acquired a foreign subsidiary and then entered into a broad intercompany license, allowing the parent to use and further develop the subsidiary's IP, while at the same time left very little remaining substance in the subsidiary, whose business was then effectively wound down. The court in the subsidiary's jurisdiction held that despite formal ownership remaining with the subsidiary, the economic ownership had moved to the US, and the tax authority was therefore entitled to impose an exit tax on the entire value of the company.
Well, that's a pretty sobering example.
It is, and it's not an isolated one. Like many jurisdictions use the OECD's DEMPE factors that I mentioned. That is development, enhancement, maintenance, protection, exploitation to determine who the real owner of the IP is for tax purposes. And if you have like DEMPE functions carried out in multiple countries, which is really quite common, you can end up with a situation where multiple tax authorities are each claiming a share of the income. Or else they may be asserting that the IP was under or overvalued.
Okay, so that brings us to valuation. How does that factor in?
That's another huge risk. So, when IP is sold or licensed between related parties, the transfer pricing rules require that the terms reflect what we call an arm's length price. Basically, what unrelated parties would have agreed to as the IP sales price or the royalty rate. But valuation, as we all know, is inherently uncertain. Tax authorities often come back years later and they might say, based on how profitable the IP turned out to be, your initial valuation was too low. And earlier this year, it's worth noting that the US Internal Revenue Service even issued guidance specifically encouraging its auditors to make these kinds of retrospective adjustments.
Okay, so between these exit tax considerations and the valuation issues, companies could end up being taxed twice, right? Once where the IP originated, and again where it's being used.
Yes, that's exactly right. And as one reason we stress to clients before you finalize a deal or an intercompany license, you need to think through how the structure aligns with DEMPE functions and where value is really being created within the organization.
Okay, Jim, back to you now. We've talked about tax, but there are also serious IP enforcement risks, correct?
Absolutely, Julian. Let's start with patents. In the US, to bring a patent infringement lawsuit, the plaintiff must have standing. That means the plaintiff must either own the patent or hold an exclusive license to the patent. A non-exclusive license does not confer standing. In many tax-driven licensing structures, the affiliate that actually sells the product is only a non-exclusive licensee. That's a problem because it means that affiliate can't join an infringement suit, and as a result, the company will not be able to recover lost profits or get an injunction.
Right, so a structure that works well from a tax perspective could actually undermine the company's ability to enforce its IP.
That's exactly the dilemma. If your U.S. affiliate is the one selling the product, you need to make sure that it has an exclusive license to sell. Otherwise, you're leaving money on the table in litigation.
Okay, what about trade secrets?
Trade secrets add another wrinkle. Under the U.S. Defend Trade Secrets Act, only the owner of a trade secret can bring a federal infringement action. Common law claims for misappropriation can sometimes be brought by licensees, but it's not consistent across jurisdiction. So, again, in setting up the licensing structure for trade secrets, you need to think through which entity or affiliate will own the trade secrets and which affiliates will be licensees. Equally important, you have to implement robust confidentiality obligations, and by that I mean controls over the access, use, and disclosure of the relevant trade secret, so that you can prove you've taken reasonable measures to protect the trade secret.
Okay, and are there particular concerns with trademarks and copyrights?
Trademarks and copyrights require their own analysis. The affiliate that's the registered owner of a trademark or copyright in a specific legal jurisdiction generally has standing to enforce it in that jurisdiction. But you can also grant exclusive licenses, particularly for trademarks, if the license includes proper quality control provisions. Otherwise, you risk invalidating the mark. So, across all these IP categories, getting the intercompany licensing right is a crucial not just for business operations, but also for enforceability.
Okay, so one other question I have is around employment agreements. I know those often have IP implications. Generally, how do those fit into this question of IP integration?
Another great question, Julian. Once you've acquired a target company, you also acquire new employees who often are developing or maintaining new technologies and new intellectual property rights. Their existing employment agreements, therefore, have to be amended or replaced to make clear that any future innovation is automatically assigned to the right entity in the acquiring company's organization. This means using language like, quote, the employee hereby assigns all future inventions to the designated corporate affiliate, close quote, whatever the name of the affiliate might be. And that language is necessary rather than simply an agreement to assign. The single word hereby makes a huge legal difference because it determines whether ownership transfers as a matter of law when the invention is created or whether you're stuck chasing signatures later.
And I imagine that's even more complex across different jurisdictions.
Exactly. Different countries have different rules about employee invention rights. So when you revise employment agreements as part of IP integration, you have to account for those differences or risk losing control of critical IP assets.
Uh, okay, Jim, Jason, you've both laid out some big potential pitfalls. What can companies do, practically speaking, before closing a deal to mitigate these tax and IP risks?
Yeah, and certainly, like from a tax perspective, an important step would be to map out the DEMPE functions of both the target and the acquirer, as well as the after state of what you envision for the post-closing integrated organization. You really need to figure out like which affiliates are going to be doing the development, enhancement, maintenance, protection, and exploitation of the IP going forward, as well as which affiliates will be controlling and managing the DEMPE functions. That helps you identify where value is being created and where the tax risk lies. Then you'll want to assess whether your proposed IP holding and licensing structure aligns with that reality. If not, you may want to adjust which entities perform which DEMPE functions, or if that's not practical, you might even want to rethink where IP should be legally and economically owned and how it should be licensed within the group. And one other thing I cannot emphasize enough is the critical importance of robust documentation, which should really consist of three things. First, there's transfer pricing documentation, meaning contemporaneous valuation reports and transfer pricing studies to support the arm's length nature of any IP transfers or licenses. Second are intercompany agreements for any IP licenses, assignments, or other transactions, which should be commercial, contemporaneous, and unambiguous. And third is also a best practice to have in place an audit defense file, which you can start building pre-closing, which would include additional documentation to support both the rationale for the acquisition as well as for the integration transactions.
All right. But so generally, it's about designing the structure of the agreements and documents around the business and not the other way around.
Exactly. You want like the structure to reflect how the business actually operates. And that consistency is what tax administrations really look for.
And on the IP side, you want to ensure before closing that the post-closing licensing structure will address every category of the new intellectual property: patents, trade secrets, trademarks, and copyrights, and that it will identify which affiliate will be the legal owner of each category of new IP and which affiliates will be licensees. You also want to confirm before closing that the post-closing licensing structure will provide adequate enforcement rights, for example, by granting exclusive patent rights where necessary, by including confidentiality and quality control provisions for trade secrets and trademarks, and so forth.
Okay. And I imagine coordination between the tax and IP teams on all of this is important.
Absolutely, that's critical. Like too often, tax and IP are working in parallel but not in sync. The best outcomes come when both sides collaborate early, ideally beginning with due diligence to design a structure that satisfies both sets of concerns.
And don't forget the employment agreements. Make sure they identify the specific affiliate that's supposed to own future innovations. Otherwise, you could end up with multiple co-owners across a global organization, which becomes a nightmare if one of those affiliates is ever sold or spun off.
All right. Let me see if I can summarize here. So before finalizing a deal, companies should, one, identify owners and licensees for each IP category. Two, determine which licenses are exclusive versus non-exclusive. Three, align the structure with the DEMPE functions. Four, build in those enforceability protections you talked about, Jim. Five, and review and revise employment agreements across jurisdictions.
Yeah, and that's exactly right. In doing this analysis pre-closing, it not only mitigates risk, but it helps you to project what the true cost of the transaction really is, including potential tax exposures.
And it can save a lot of pain down the road when enforcement or audit issues arise.
We like saving pain around here, so it's a great note to end on. Jim, Jason, thank you both for breaking down such a complex topic for us.
Thanks, Julian. It's been a pleasure.
Likewise, thanks for having us.
And thank you to all our listeners for joining us on Tech Talks. If you have questions about today's episode or an idea for a future one on technology and IP transactions in the law, please email us at techtransactions@mayorbrown.com.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayor Brown audio programming, visit mayorbrown.com/podcasts. Thanks for listening.